today with a session about the Turks and Caicos Islands inside one of the world's largest asset recovery programs. And in the schedule, only one speaker is listed. That's James Maton on your far left. Fortunately, Laurence Harris, who wasn't sure whether he could or couldn't make it, and at the last minute was able to join us. So Laurence is to my immediate right, and they're both with Edwards Wildman, which has been leading the very high-profile and very big-scale asset recovery program on behalf of the Turks and Caicos Islands authorities. The Turks and Caicos Islands had quite a few problems to the point where the British government intervened a few years ago, and they're in the process of trying to sort of clean everything up on behalf of the country and sort of take it forward and away from its past. So I'll leave you two guys to make your presentation.
Great, thanks very much indeed. Let's see if we can get some slides. Here we go. This morning we plan to talk about the Turks and Caicos Islands and the civil recovery program there. And in fact, to sort of set that in context, what we plan to do is to first of all start looking generally at the mechanisms for recovering the proceeds of corruption, and we'll use some examples from the TCI and the different routes that one can follow: criminal confiscation, civil recovery and forfeiture, and private civil proceedings. We'll look at the advantages and disadvantages and how you decide what the best mechanism is for doing that. And we'll give that background in order then to put in context the work that's been going on civil recovery in the Turks and Caicos Islands, and how we came to approach it and the way we did and what's happened, so you can see how it's kind of worked together. James and I are going to do a double act. We've both been involved in the civil recovery program in the TCI since its inception, and I'll talk a little bit later about how it came about, that we became involved, and what we've been doing. I think we've been timetabled for, well, about an hour and 20 minutes from now, and I think we might struggle to talk for an hour and 20 minutes non-stop, and you will certainly get bored if we talk for an hour and 20 minutes non-stop. So please do ask questions along the way, or at the end. We'll have some time for questions at the end, and we're very happy to answer questions. And what we really want to try and demonstrate, as well as giving you a bit of insight into what's happened, is how asset recovery is one part of a process of demonstrating good governance and for demonstrating the ability to attract external investment into the country, confident in the country's institutions and performance. So, James.
Thanks, Laurence. To start off with some examples of corrupt behaviour across the world, I think the themes of corruption tend to be consistent across countries and through time. And whenever you have, in a country plagued by corruption, government officials, public officials responsible for decisions on which large amounts of money can turn, you obviously have lots of scope for corrupt behaviour. Bribes paid to win public contracts, to obtain public assets at substantial discounts or free of charge are obviously common in many countries that have suffered corruption. Some of the claims that we brought in the TCI were for the recovery of public land called Crown Land, land that was sold, the government said, at very substantial discounts because of illegitimate behaviour of one kind or another. And Laurence will talk about that in a bit more detail later on. Coupled with that, of course, where you have concessions of any kind, whether they be mining, oil, Crown land that's going to be developed for tourist resorts, whatever it may be, you're going to need the government to grant development rights, and you're going to ask the government for concessions against tax and so on. And in fact, in the first session yesterday, reference was made to some of the problems in Africa, where mining concessions worth enormous sums of money have been given away by African governments under enormous pressure to give the most significant concessions, which means that taxation revenue is not going into the country. In the TCI, some of the claims that we have made have been that concessions were made against various duties and other forms of payments that were due to the government in return for illicit behaviour. Laws which were introduced for very good reasons, to empower local citizens, to make sure that local citizens can share in the economic success of a country, often give discounts to those citizens for buying, for example, land or to get some other right, and they are often a vehicle for abuse, where those that want to get hold of those assets at a substantial discount will obtain them by the mechanism of using local citizens to flip the land onto them. Sometimes those local citizens will make very significant amounts of money, sometimes they won't. Very often where they do make substantial amounts of money, you find that those that are involved in the flipping of the asset, whatever it may be, are a small pool of individuals closely connected with the leadership of a country. And you see examples of that across the world. Evasion of tax and duties, such that they are, is another vehicle of corruption. One of the cases that Laurence and I did in the TCI involved the alleged evasion of stamp duty on a substantial property discount by various contracts which were said to be valuable and to which purchase price was allocated, and which we alleged had no value at all. Very often in many countries around the world you see special knowledge. I mean, this is a difficult area where public officials have some kind of special knowledge because of their position. For example, they may know that a mining concession is going to be granted, let's say in one of the African countries, and that company coming in is going to need to build a road from the airport to wherever the mine is, and therefore they know that the land values around that road are going to become very elevated in the near future, and therefore they use that knowledge to allocate that land to themselves, safe in the knowledge that at the moment it's worth very little, but in the future it's going to be worth a large amount of money. And the consequence of all of this, of course, is that contracts are performed badly, assets are sold well below market value, revenue to the government is depressed, and the economic and welfare of the citizens of a country are very badly damaged. And you can see that in Ukraine at the moment, where the estimates of what has been stolen vary enormously, but you're looking at something, depending on which article you read, from 20 billion to 80 or 90 billion, just over a few years of money that's gone from the government treasury there. Form of bribes, obviously they take as many different forms as you can imagine. Cash payments, political donations, shares in companies which have been established to win public concessions. Very often, good works that are being done as part of a concession. For example, an investor coming in will be asked to build a school or a hospital or whatever it may be as part of their deal. All very good, something that we want to encourage. And then you find that the public official's brother owns the company which is going to be building that school or building that hospital at a vastly inflated price. What are the options for a government that want to recover the proceeds of corruption? I mean, the government's in a special position in a way, in that it has a range of criminal and civil mechanisms available to it which can be deployed. And on paper, if you read, for example, the United Nations Convention Against Corruption, they all look pretty impressive and they all look pretty effective. What we must remember is that, estimates of the amount of corrupt assets generated each year, again, vary enormously, depending on which economist you talk to. But it appears to be in the order of tens of billions of dollars per year, even on some of the lowest estimates. The total amount ever recovered in corruption assets, which is a fairly firm figure, excluding China, where we're not entirely sure what the figures are, is about $5.5 billion, a tiny fraction of the amount of corrupt assets per year. Why is that? Well, the main reason for that, of course, is the political influence of those that are engaged in corrupt behaviour. That is the major problem facing asset recovery cases in any jurisdiction around the world. And there's lots of conferences that talk about all the different ways that you can make asset recovery more effective in the context of corruption. But unless you solve that problem, all of those improvements are going to have very little impact. So what can a government do? Well, the historic route, of course, is to prosecute those that you regard as engaged in corrupt behaviour. And if you are successful in obtaining your conviction in most countries around the world, you're entitled to confiscate their corrupt assets. And that order can be obtained and enforced domestically, or it can be obtained in the country where the corruption has taken place, let's say, and taken abroad internationally for enforcement against assets held in other countries through the process of mutual legal assistance. Again, on paper, on the international treaties, that is meant to be an efficient and effective process. The examples where it has worked efficiently and effectively across borders are very, very few in number. Domestic civil forfeiture and recovery. Many countries around the world have introduced this legislation permitting law enforcement to bring civil proceedings effectively, either the law enforcement agency itself or through vesting powers in an Attorney General or some other Minister of Justice or so on, to recover the proceeds of criminal conduct in the absence of a criminal conviction. And that can be taken using the evidence which is gathered in a criminal investigation. Where that works, that can be a very powerful mechanism indeed to recover assets. And again, there is meant to be an international regime in place where forfeiture orders obtained in one jurisdiction should easily be able to be enforced in other jurisdictions. Once again, it proves very difficult in practice in many cases. Foreign criminal or civil forfeiture proceedings. Usually in international corruption schemes, there are criminal offences which are being committed in various jurisdictions around the world, money laundering being the obvious one. For example, the Nigerian government has recovered a large number of assets, particularly from the UK, where the UK authorities have taken criminal proceedings for money laundering arising out of corruption in Nigeria. And then the UK's policy is to repatriate those proceeds where they're convinced that they will be used properly for public purposes. That, of course, can be a very effective mechanism to recover the proceeds of corruption where there is doubt as to whether it is realistic to obtain a criminal conviction in the country where the underlying corruption has taken place. Of course, the biggest beast in that area is the US Department of Justice, with their enormous powers and resources to recover or to take criminal and civil forfeiture actions. And there are numerous examples of where they have taken successful action where in relation to corruption, where foreign governments have struggled to do so. Of course, the last option, private civil proceedings, usually where a government has been defrauded, it's lost one of its assets through bribery or theft or whatever it may be. Just like any other person who's been deprived of their assets, they usually have the capacity to bring civil proceedings, either in their own country or in the country where the assets have been located through private lawyers. Private civil proceedings can also give rise to contractual remedies. For example, if you've entered into some kind of concession agreement and it later transpires that that concession agreement for a mine, for Crown land, for whatever it may be, has been procured by bribery, typically there are termination rights in those contracts which can be exercised. A whole range of torts as well, depending on which jurisdiction the litigation is taking place in. And what private civil proceedings probably are better at, I mean, there's no real reason for that, it just seems to work in practice, is to look at third parties who have been involved or participated in the corrupt acts that are not themselves the person who is paying the bribe or the person that has received the bribe, for example. It may be lawyers or accountants or banks or whoever it may be that have knowingly participated in that scheme and may be the subject of action as a result. In the Turks and Caicos programme, which Laurence will talk about in a moment, that has largely, our part of it, has largely been private civil proceedings brought in the courts of the Turks and Caicos Islands, largely to recover land which the government said it was entitled to recover. I thought I'd briefly go through some of the advantages and disadvantages of those various routes. With the starting position, really, of this, you meet lots of people, I think a declining number, but still lots of people, who are very wedded to one particular recovery mechanism for the proceeds of corruption. You will meet criminal practitioners, for example, who sometimes say, well, we're dealing with criminal behaviour and therefore there should only be a criminal response to recover these assets. And these civil lawyers, they're terribly expensive, they can't get hold of evidence in the way that we can, etc., etc., etc. And you get civil lawyers who say, look, you've got to take private civil proceedings, that's the only possible route, it's far more effective and quick, and so on and so forth. And the reality, of course, is that it depends entirely on the particular circumstances of the case. All of these routes have their own advantages and they all have their own disadvantages. And you have to find the right route for the particular case that you are dealing with. As a personal view, my view is usually that the criminal route is where you would start. You are dealing with criminal behaviour, and that's probably the best route as a result. But there are many circumstances in which the criminal mechanism will not be the most effective mechanism to recover the proceeds of crime or the proceeds of corruption, and therefore you need to look at other routes. One of the first questions there, of course, what is the public interest? There are some corrupt or acts of corruption or corrupt actors where it is so serious that the public demand that there has to be a criminal response. And I think those that are looking to recover the proceeds of corruption have to think quite carefully at the outset as to whether the most important thing is to secure that criminal conviction or to recover the assets. Of course, if you can do both, fantastic. But there are many circumstances in which a more difficult choice has to be taken. And of course, one question in all of that, is conviction available or realistic? I think there are a lot of files in law enforcement agencies around the world where very good criminal investigations have taken place, and for whatever reason, they have not been able to go forward into a criminal prosecution, or a criminal prosecution has failed for one reason or another. And those files have then laid dormant with no action being taken against the assets in circumstances where realistically action could have been taken to do so. There's no point pursuing a route that can't be taken forward to a conclusion. I acted for one country where the criminal route was taken, and only the criminal route, and the defendants managed to secure 292 adjournments of the criminal process until they got to a stage in time where, for one reason or another, the politics of the situation had changed and they were able to kill the proceedings. The efficiency and fairness of the courts and the appeal process needs to be considered. If you are taking a criminal process in the courts of a country where there is concern about whether a fair trial will be secured, and you get a conviction in that court, and you get a confiscation order in that court, and then you go overseas to enforce that confiscation order in London or New York or Paris or wherever you want to enforce it, you will undoubtedly be met by the claim from the defendants that they did not receive a fair trial, that the conviction is unsafe, and that confiscation order should not be enforced. And of course, judges in those jurisdictions are very concerned about the fairness of the process, and they are very concerned about it, particularly in the political context, because they're unsure as to how comfortable they can be in many circumstances with that conviction, and that's going to cause substantial delay. In my view, where you're looking to recover assets, it's usually best to bring your proceedings in the jurisdiction where the assets are located, because then you only fight the case once. You don't have to fight it once in your own country, and then you don't have to fight it again at the enforcement stage in another. And in many of these cases, you need to bring them and win them in a short space of time. Otherwise, time can be your enemy. Other things to consider. The ability to obtain evidence. Law enforcement, quite plainly, are the organisation which is best placed to obtain evidence using their very sweeping powers to do so, both domestically and internationally. There's often much less opportunity for coercive powers to obtain evidence in civil cases, at least quickly and at least in a meaningful fashion, and certainly much less opportunity at the investigation phase. But if you do need evidence across borders, of course, one question is whether you can get mutual legal assistance from whatever country you're going to try and get it from in a sensible matter, in a sensible time frame. There are some horror stories around the world of incredible delays in executing mutual legal assistance requests. I think the situation is probably getting better, but in some jurisdictions still it can be very slow indeed. Of course, another question allied to that is to what extent can defendants be forced to provide disclosure? Often in a criminal process, they can't be forced to provide disclosure. Often in a civil process, at one stage or another, they can be required to give disclosure, and that can be very important. Of course, if you're in a liquidation situation and you've got the ability to appoint liquidators over companies or other entities that hold what you believe to be corrupt assets, they have very wide powers indeed to get evidence from all sorts of people. Of course, another thing to consider, the ease of freezing assets. Usually desirable in all corruption cases or another dishonest cases to freeze the assets right at the outset of the case, because they're not going to be around at the end of the case if you don't. Usually law enforcement are better placed to freeze assets at an early stage. They've got the powers to do so normally in support of an investigation. If you're freezing assets in a civil case, you normally need to get on with your case very quickly afterwards if you've not brought it already. Other issues to consider, and this is an issue that we've had to consider in the Turks and Caicos. Do contractual relationships need to be terminated or recast? Let's take the mining example that was used yesterday. If you've got a large-scale concession for a mine that was procured by bribery, you're going to have a complex contract that if the bribery is sufficiently serious, that you may want to terminate that contract. Usually, the civil courts are better at dealing with termination and the consequences that flow from termination. And that can particularly be the case if you're in a situation where there is a risk that if you don't act quickly to terminate that contract, a judge is going to decide that you've waived your rights to terminate that contract because you've taken far too long to think about it. And if you've got a situation where you're dealing with a contract where you have decided that there will be a criminal investigation into how that contract was obtained, entirely possible that may take a few years. And the person that's got the benefit of that contract will be saying, you have waived your rights and you cannot now terminate that contract. And that means you could be stuck with that contract if the conclusion of the criminal process is not that there has been criminal behaviour. Standard of proof, big factor. Corruption cases, you are very often relying on inference. Very rarely do you have a complete document chain. The civil test of winning a case on the balance of probabilities is clearly a much easier test to satisfy, even when you're accusing people of quite serious misconduct, than proving a case beyond reasonable doubt in a criminal court. And unless you have that overwhelming evidence and that compelling evidence, you may need to look at other routes than the criminal route. Criminal proceedings generally have a more rigid regime for the admissibility of evidence. Most of my civil cases around the world, I can rely on virtually any piece of evidence I like, save for evidence obtained by torture. In the criminal context, there is much more rigid and difficult rules sometimes as to what evidence can be deployed. And in some cases around the world, that's proved to be a barrier. Availability of settlement mechanisms. Settlement of corruption cases is one of the most controversial subjects in the field of corruption. If you look around the world at the settlements there have been, they usually involve one of two things. Somebody is given immunity from prosecution, or somebody gets to keep a proportion of the assets which are regarded as corrupt. And you can quite easily see why reasonable people can differ quite seriously as to whether that is an appropriate thing to do or not an appropriate thing to do. And of course those who advise on settlements, those who enter into settlements, are weighing up a whole series of factors, not least the cost and time it's going to take to get to the end of the process, the merits of a case, and everything else. But those settlements do cause great controversy. Usually, I mean, this changes from jurisdiction to jurisdiction, it's usually easier to settle cases through a civil process than it is through a criminal process, unless, of course, there's a plea bargain mechanism quite overlooked, actually. There probably needs to be an academic study about this. And we sort of just speak really from our own experience of running corruption cases in various countries. The amount that you can claim differs enormously within a jurisdiction between the criminal and civil process, and it differs enormously between jurisdictions. So if you have a situation where you may have underlying corruption in one jurisdiction, the proceeds of that are laundered to another jurisdiction, it may well be that the second jurisdiction can give you a much higher recoverability in some circumstances than the first, or it may be the other way around. In some cases, the criminal route offers a much higher recoverability. For example, if you can take all the revenue that's been earned under a contract in some forfeiture schemes. In other cases, the civil case can. Something that needs to be weighed up if you have the time to do so and the resources to do so very often at the start of the case, because the swings can be dramatic. Third parties we've talked about. There may well be third-party participants in corruption schemes, in fraud schemes, that may well be suitable targets for proceedings because of their conduct. Criminal proceedings against those people may be impossible, difficult, undesirable for a whole series of reasons. And finally, use of insolvency remedies. My own personal experience of this is relatively limited. I've done a couple, others have done more, but in many jurisdictions there is power to appoint liquidators over companies that hold corrupt assets, as I mentioned, and where available and where it's going to work, that can be a very effective mechanism indeed, because the liquidator effectively becomes that company with all the powers or rights that company has to obtain documents and obtain evidence and to force people to give them information and documents, which can be very important indeed for tracing assets and for making claims. I thought I'd briefly mention funding. Funding can be very difficult for impoverished governments that have suffered from large-scale corruption. There's obviously a number of different routes that can be used to fund these cases. Many governments choose to fund them themselves. There are grant and donor organisations as well that in some circumstances will fund anti-corruption or asset recovery programmes. And of course the third-party commercial funders are becoming increasingly interested in this area, as they are in litigation generally in many jurisdictions. I think the levels of fees that they are currently expecting, I think you're looking at somewhere between 20 or 40% of recoveries that they will require to fund litigation and to pay all the legal fees, are usually prohibitive in corruption cases. I think it's very difficult for a government, it's all very well for a government to say, I'm getting all my legal fees paid, everyone's very happy about that, it's not coming from the public purse. Then there is a major recovery, 40% of it goes to a funding organisation, which will then be described in the media as some hedge fund in London or New York or wherever it may be. And I think that's very politically difficult for governments to deal with. That percentage may come down with time as there's more competition in the area, but we're a long way off that at the moment. And then, of course, in some jurisdictions, you've got contingency fee arrangements, contingency agreements of one type or another as well. They probably suffer from the same political problem. Concluding thoughts as to that introduction before we get on to the TCI. In my experience, the best route for a government asset recovery case or programme depends on the facts and on the circumstances which exist. Most large asset recovery programmes will need a mix of mechanisms. Very often, dual criminal and civil processes are both necessary and most effective to achieve overall success, obviously structured in the right way, because in most jurisdictions those teams will need to be independent of each other. Too often, in many countries around the world, there is not sufficient analysis of which is the best route for the particular case or series of cases that they have, which is obviously a major hurdle. And many governments should consider more use of foreign enforcement agencies. The US Department of Justice, various agencies in the UK, particularly the Proceeds of Corruption Unit of the Metropolitan Police, are very keen indeed to do more work for foreign governments who have seen their assets laundered through the US, UK or jurisdictions where they touch. where sensible agreements can be put in place with those agencies for the repatriation of assets, that can be a very effective mechanism indeed in circumstances where domestic routes are going to struggle for one reason or another. Funding and political will are the essential elements to consider at the outset. You need to have the buy-in to programmes of this nature at the highest level, otherwise they're not going to succeed. And with that introduction, we'll hand over to Laurence to talk about the TCI.
Great. We'll talk about the Turks and Caicos Islands. Now, in London, if I talk about the Turks and Caicos Islands, people look at me blankly because they don't really know where they are. I'm sure this distinguished audience knows exactly where the Turks and Caicos Islands are, about an hour and a half's flying time from here, at the end of the Bahamas chain, and they are a UK overseas territory, and that means that they have a constitution, a freestanding constitution put in place by the UK government, which provides for an elected government, for a ministerial cabinet, an elected House of Assembly, and with a governor appointed by the UK, in whose name the actions of the government are carried out, and who chairs the cabinet. The constitution carefully defines the roles of the various players in the TCI and in other UK overseas territories. And there's been actually a relatively new constitution in place in the TCI, in place now for a little while. And that provides for safeguards, for example, the statutory independence of the Director of Public Prosecutions. There's separation of powers between the DPP and the Attorney General now. That wasn't historically the position in the TCI and other UK overseas territories, but now, generally speaking, there are separate people performing the roles of the DPP and the Attorney General, and each is underpinned, their roles are underpinned with independence provided for in the Constitution. So that's the framework. And what happened here, as many of you will know, is that the UK government established a commission of inquiry, which was established in 2008 to investigate and report on persistent allegations of corruption that were circulating in local media and elsewhere. And that commission was headed by a senior UK judge who went out to carry out the commission of inquiry. His name was Sir Robin Ould. And he set up an inquiry which received submissions, which received evidence and received confidential information. And hearings were held in public, and interested parties were represented, and there was cross-examination of witnesses. And this was reported on day after day in the local media. And so what perhaps had previously not been given so much airtime was given an enormous amount of publicity and airing. And that dominated the local news agenda at the time, and obviously gave rise to substantial public interest and knowledge of the various matters that Sir Robin looked at. And in 2009, Sir Robin produced a report, a pretty thick report, which concluded that there was credible evidence of corruption. And he made a whole host of recommendations, very large number, to do with very basic issues, the way the Constitution was set up, the running of the islands, but he also looked at some of the issues and made recommendations about criminal investigation and civil recovery. And the UK government accepted those recommendations, actually at that stage suspended the then Constitution, and set about a process of implementing Sir Robin's recommendations through various milestones that were put in place in order to go through a period and move back to constitution and elected government, which has now happened. And in relation to the recommendations, the specific ones that we're most concerned with today are recommendations in relation to criminal investigation and into civil recovery. And in relation to criminal issues, a special investigation and prosecution team was set up. And I'm not going to say anything about the criminal process for two reasons. First of all, it's not something that my firm has any involvement in. We're exclusively dealing with civil recovery. And secondly, because there is an imminent criminal process taking place and a trial scheduled to take place this summer in the TCI. So that has, the criminal side, quite separate, has been going its own way and will continue in its route. We, on the other hand, became involved on the civil recovery side, and the civil recovery team was intended to be led by Chambers, by the Attorney General, and to take on board experts to assist with the process of dealing with civil recovery. And that was the recommendation of Sir Robin, that there would be a process of civil recovery to seek to recover some or all of the assets that he believed and identified might have been disposed of improperly or without fair value. And so the process started with, towards the end of 2009, when the Turks and Caicos Islands Government, led by the Attorney General, went out to a tender process to appoint lawyers to assist the government in civil recovery. And a tender process was held in London, and a number of London firms, ours included, were invited to come for interview and to tender for the work. And six firms, I believe, were asked. And at the end of 2009, my firm was appointed to assist Chambers with civil recovery. And James and I have been the two partners who've been principally responsible with various associates at our firm for the civil recovery process. We have both been admitted to the TCI bar for the limited purpose of assisting with and dealing with civil recovery cases. So we're not allowed to take work from anyone in the TCI, but the government, and our admission extends only to helping with civil recovery issues. And we work very closely with Attorney General's Chambers and have done throughout the process of the civil recovery programme. Generally, although both James and I have rights of audience to appear on civil recovery cases in the TCI courts, we've used barristers. David Phillips is our main barrister from Wilberforce Chambers in London, who has been out also with limited admission doing the lead work on a lot of the cases, assisted by Patrick Patterson, who is actually an Anguilla barrister, attorney, and is himself a former acting Attorney General of the TCI and very familiar and had a lot of experience in Chambers in the TCI. So that was the sort of team that was set up. Now, when we started, we obviously had the benefit of Sir Robin Ould's Commission of Inquiry report, which by then had been published. And very helpfully, we started from the process of having all the evidence and the conclusions that he had amassed. And he had identified a number of transactions and issues which he thought were a very serious concern, and that was effectively our starting agenda in terms of looking at civil recovery cases. But as time has gone on, other issues have also come to light. So we have been dealing not only with issues raised by Sir Robin in his report, but with other issues that have come along that he didn't identify, but which have also given rise to concern and to cases. Most of the cases are about land. Land is TCI's single biggest asset. For those of you who haven't been there, it has stunningly beautiful beaches, is a very popular tourist destination, particularly with Americans, And there's been a lot of resort development on the main island in Providenciales, but also to a certain extent on other islands. And those developments have involved ultimately the acquisition of land from the government, because the government historically has been the biggest landholder, as you would expect, of the islands, and over time it has disposed of land. And a lot of the issues identified by Sir Robin were in relation to the disposal of Crown land. And so a great deal of what we have been doing has been looking at the disposal of land and seeking to recover it. So perhaps slightly unusually or differently compared to other civil recovery programs and issues around the world and other countries that we've acted for, where we might have been principally concerned with money and recovering money that had been taken. Although money has been an important part of what we've been doing, land has been a really important feature. One of the important things that we have been trying to do, the civil recovery process has been trying to do, has been to recover this very important asset for the government and for the people of the TCI for its long-term benefit. The programme is, in fact, now mostly completed. We still have some cases going. And in fact, that's why I was slightly uncertain as to whether I'd be able to come, because we were having an appeal in the Court of Appeal yesterday. But most of the cases are now completed or in the course of being completed, and I'll come on a bit to that in a minute. Generally speaking, as James said, almost all of our work, in fact all of our work, has been in what James illustrated as the fourth category of approach to civil recovery, that is, civil cases brought by the government as a private party would do in the civil courts. We have not been concerned, as I said, with the criminal process, which is entirely separate, nor have we been concerned with civil forfeiture, which, although under the TCI Constitution the Attorney General has powers to bring, civil forfeiture has again been something that has been looked at exclusively by the criminal team, the Special Investigation and Prosecution team. So we have not been involved in that either. We have simply been dealing with civil cases with the government acting as private party in the courts in the way that any other private party would do. Now, you may ask, well, what about the courts? How does that work? In the TCI, there are effectively two tiers of courts. There is a Supreme Court, first instance. There are currently 3 full-time judges in the TCI, 2 principally dealing with criminal work and 1 principally dealing with civil work. And so our cases are generally heard by the principal civil judge in TCI, who is relatively new. And in our time over this programme, there have been 2 or 3 different judges who have been there taking the lead role in the civil cases, and sometimes people coming sort of out of semi-retirement to assist with the workload. There is a right of appeal, generally as of right for final decisions, to the Court of Appeal. The TCI Court of Appeal is comprised of a roving bench of 3 retired or semi-retired Caribbean justices who sit at the TCI Court of Appeal and who come now 3 times a year. Used to be 2 times a year, but they've been kept a little busier of late. So they now come 3 times a year for 2-week sessions to deal with appeals. And then there is theoretically a further right of appeal to the Privy Council in London, as with most of the other overseas territories, but that is with permission either of the Court of Appeal in TCI or of the Privy Council in London. And we do have cases that go to the Privy Council in London. We've had 2 cases so far from the Civil Recovery Programme that have gone to the Privy Council in London, and we'll have to see in due course whether more go from the Court of Appeal upwards. And the civil process takes a little while, as you would expect, although actually it has got rather faster as time has gone on over the programme. And generally speaking, cases are taking between a year to 18 months to perhaps 2 years to get from start to finish, certainly at first instance, depending on how big they are, how much evidence there is, and then normally another 6 months or so for an appeal to the appeal court. The claims are all brought in the name of the Attorney General and are brought in the civil courts, as I say. And we've had a wide range of cases, but the kind of principal feature has been, or the common feature has been, in a lot of them, has been the recovery of land. And so far we have recovered just over 3,000 acres of Crown land, which in the context of islands like the TCI is a very substantial amount of land, and about $23 million of money either has arrived or we've obtained judgments or settlements that mean money is due to come in of that sort of sum. And we have had from time to deal with counterclaims against the government, which are raised in proceedings, and those have generally not been successful. So it's been a reasonably successful process. As James mentioned, one of the things that civil courts can do in this process is restructure agreements. And as part of the proceedings and the settlements, we've also done some restructuring of various agreements that the government made so that they have been able to go forward successfully as well. The sort of key hallmark, we think, of why the process has succeeded so well in the TCI is the last point that James made, is because there has been really from the outset serious political will to bring the programme of claims and to see them through, and that has been critical. We've had 3 governors in the time that we have been there, and 3 Attorney Generals. We're now on our 3rd Attorney General in TCI, but all have been very strongly resolute in their desire to see the civil recovery programme through. And that has been a very important feature of the programme. Now, as I said, we were very fortunate that the Commission of Inquiry had generated a substantial volume of evidence at the outset. So we had a kind of ready-made library of material to start working from. Now, of course, that material didn't necessarily, wasn't conclusive, and had to be taken for what it was, which was material disclosed in that Commission of Inquiry, and there were certain restrictions under the Commission's rules as to what you could do with it. But it was a very, very good starting point. And often in civil recovery programmes, and where we've been involved in programmes in other countries, one has not started from a position of having so much material available at the outset. But as I said before, our work has not solely been in relation to what the Commission identified. And as time has gone on, the government has found other things that it's been concerned about, and we've had to look at those things from scratch in the ordinary way. And that has been inevitably time-consuming, but also reasonably successful in being able to use the civil process through disclosure and other things, and actually through people generally being very helpful and supportive in taking forward those claims. Most of our cases, in fact almost all our cases, have been brought domestically. They've been brought in the courts. Courts have a very good reputation in the TCI for being independent, fair-minded, and we've been able to bring those cases domestically. We've had almost no examples of cases where we've had to go to different jurisdictions or where assets have been moved outside the jurisdiction. And that principally, of course, is because we've been dealing with land. And land, fortunately, doesn't move. It can't be taken by someone in their suitcase away to a different jurisdiction. And that's been very helpful in terms of enforcement processes, because the assets that we have generally been looking for have been there present in the jurisdiction, and we've been able to go after them without some of the complications that you often find in civil recovery programs, where assets have been moved from one jurisdiction to another, have gone through different hands, and there are tracing and other issues that are involved. And one of the other features that has been really excellent has been the strengthening of the chambers, the Attorney General's chambers. When we were first appointed, Attorney General's chambers was really quite small and substantially under-resourced, and indeed it's one of the things Sir Robin identified in his report as one of the ways in which things had been allowed to take place that ought not to have taken place was because of the under-resourcing of chambers, so that it was unable to cope with the volume of work that it was doing and unable to monitor and be involved in all the things that it ought to have been involved in because it simply did not have the people and the resources. And one of the milestones that were put in place was the substantial strengthening of chambers. That's been happening over the last few years. It's now much better resourced than it was, and much more able to take on board and monitor and deal with everything that the government is involved with, which not only has the benefit of ensuring that the government gets the best legal advice it can on what it is doing, but also has the benefit of ensuring that lawyers are involved in everything that the government is doing. And that's been a very, I think, positive and a beneficial thing. And those of you who follow TCI News will have seen that recently new Attorney General was appointed, who is a local, who was the Deputy Attorney General, and her appointment has been very well received by people across the islands, and she is doing a tremendous job in working with the newly elected government, as well as with the governor in finishing off the civil recovery programmes and in other issues, but also in taking forward the next steps in the development of the country as it puts behind it the issues that were identified by Sir Robin and moves on in the country's development. One of the other things that was put in place was an integrity commission, and again, this was another recommendation that came out of Sir Robin's report, and something that the UK government took on board, and it put in place an integrity commission, and this was a new feature for the TCI. There had not been an integrity commission before this stage. It was inaugurated in May 2010 with the responsibility of promoting integrity and honesty and good faith in public life in the Turks and Caicos Islands. And it's been given resources, staffing, and it's been given a remit, which I've put up on the board, because it's worth just spending a minute or two looking at what the Integrity Commission is responsible for, because it's one of the ways in which the TCI is looking to move forward from its past and put it behind it. So one of the things that the Integrity Commission is now responsible for is compliance concerning declarations and statements of interest filed by people in public life. There was previously a process by which ministers and parliamentarians would make declarations of interests. And that was identified by Sir Robin as a significant weakness in the way that matters had been taken forward. And the Integrity Commission, that there was no policing or oversight of those declarations. So the Integrity Commission has been given the role of managing compliance with that, which is an important new feature that's been put in place. And they've been given the role of investigating, if relevant and if they think it's appropriate, the accuracy of the declarations that are made. They've also been given the role to receive complaints about allegations of corruption, which come within their statutory mandate, and to carry out investigations in relation to those allegations. They've been given the role of maintaining transparency and integrity in relation to party finance, which was another area that Sir Robin identified as being a sort of serious past weakness about the misuse of party finance, and they've been given the opportunity or the role to oversee that. And there's a new political activities ordinance that has been put in place. There are now limits on the spending by political parties, and the Integrity Commission has a responsibility in oversight in relation to that. And it has a more general role, which is to contribute to the public education about integrity in public life and the work of the Commission generally, and to promote high ethical standards. The Integrity Commission is independent. It's headed by someone who is very well known, actually from outside the islands, very well known, very well respected figure. It's been given resources, and that is one of the ways in which the TCI has taken a very positive step to move past its recent history and put it behind it, and put in place safeguards that will enable it to move forward confident that there are now appropriate checks and balances and oversight to ensure that, that what happened before can't happen again. So that's one measure, and in fact there have been a number of such measures, but that one in this context is very important. TCI has been able to demonstrate a very strong commitment to governance and effective regulation, and it's done a lot of work in relation to its governance and regulation to ensure that it has now a much more robust framework. And part of that's the new constitution that's in place, and part of that, which has led to the resumption of elections, the resumption of elected government, and part of that is the Integrity Commission, and part of that is a number of other different features that have been put in place to support and strengthen ethical standards in public life. And those frameworks, but the determination to see through a civil recovery programme, a substantial programme, really underlines the commitment the government has to good governance and to moving forward. One of the other features for those of you who follow TCI matters is that the TCI, like many countries, has struggled fiscally, and that coincided with the downturn in 2008, 2009, and that also coincided with the appointment of Sir Robin and the Commission report. So it sort of had to deal with all of these things in one go, which was would have been pretty challenging for any government, but not least for government in TCI, whose principal revenues are derived from tourism, and obviously tourism also went through a difficult period. One of the things, again, that TCI has been very keen to do is to put in place a very strong fiscal framework to ensure that it runs a balanced budget, a prudent budget, and that it's been doing, and the elected government has taken responsibility for that and is seeing that through. And so there is a sort of theme, really, of which the civil recovery is just a part, which is to see through sound governance, good governance, appropriate frameworks to put the country into the best possible position it can be going forward. And of course all of that is designed to make TCI as attractive an investment environment as it can be, because it wants to be and is very much open for business and seeking to attract inward investment. And that, of course, is where everything comes together, because civil recovery is but one part of a broader framework of encouraging investor confidence to come into the islands, in encouraging people to invest in the islands, because what we know from our experience in other countries, and I think as everyone knows, is that if there are concerns about corruption, then that is a really bad thing for investor confidence, and it erodes and eats away at the desire of investors and the confidence that investors feel in coming into a country and investing, and in that country then turning around its fiscal strategy and doing well in terms of having a sound and balanced framework. And so what one sees in countries where corruption gets out of hand is that investor confidence falls, and and so things get worse, and you move into a depressingly familiar spiral. And one of the most encouraging things about TCI is how it's actually managed to reverse that spiral. And it has gone from a position where it was written about widely and where there were widespread concerns to a position where it is very much open for business, where it has put in place very strong fiscal framework, where it's demonstrated its determination to see through this very substantial asset recovery programme and put in place many of the other milestones that it set about putting in place after Sir Robin's report. And one is now seeing investors returning to TCI, which is very encouraging, and indeed there have been a couple of very big investments recently. There's a very big development going on West Caicos, which was concluded. The investment was agreed last year. That's going to be a very substantial development. And another recent development that had stalled has recently got going. And there's a much greater level of investor confidence in the framework that the country now has. And that's very encouraging to see. And it demonstrates really how civil recovery fits into a wider context, which is all about good governance, investor confidence, and having a clear path forward as a country with a clear set of goals and aims, which it is operating to, as the TCI now is. And it's been really our great pleasure to be a part of that process, not only recovering the land and the money, but seeing how that fits into the wider context of the developments going on in TCI. A few concluding thoughts, I think, from James, and then we will have time for questions.
Just brief remarks on the future of asset recovery generally. We said several times, political will, the biggest obstacle anywhere in the world to successful asset recovery, and that is a problem that has to be solved if there's going to be any meaningful increase in the proportion of corrupt assets taken each year. Everything else really, I think, is just detail. Lots of ideas floating around. Should the jurisdiction of the International Criminal Court be extended to include at least grand corruption? Obviously, that is a court which has received a great deal of criticism, fairly or unfairly, in recent times, but is an institution which could conceivably undertake such a role. A specialist international corruption court trying to take enforcement action against the proceeds of corruption. Universal jurisdiction to domestic courts in many cases involving crimes against humanity. Some jurisdictions have given themselves universal jurisdiction to prosecute those crimes. Could that be part of a package of efforts to address the problem of corruption? Legitimate civil society groups. Obviously, in many countries that have suffered widespread corruption, there is a lack of effective civil society groups because they've never had the opportunity to be created and develop. In many other countries, there are very active civil society groups. Should they have the ability to bring claims where they see the government failing to do so? One mechanism for that possibly is the US mechanism of False Claims Acts, where concerned citizens are able to bring claims where they think the government has been defrauded, giving the government the opportunity to take over that case. And if the government does and is successful, a reward is paid to the individual that brought it in the first place. If the government declines to bring the case, the individual can carry on and then gets a bigger proportion of the cut if the case is successful. Perhaps that's part of the answer in some jurisdictions, at least where there can be confidence in the courts to fairly decide those claims. And of course, the international community has found it easier to freeze what it regards as the proceeds of terrorism. And international mechanisms have been brought into play to do so. obviously also generating concerns in some areas about civil liberties and so on. But are those mechanisms a possible route to more widely freeze, restrain the proceeds of, at least again, grand corruption, which is devastating countries around the world? We talked yesterday at length about publicly available filings on beneficial ownerships of companies, whether or not that will happen. I won't say much here other than to say, of course, in any investigation, trying to work out who owns what companies is sometimes a very difficult exercise indeed, and the more information that is available will increase the effectiveness of any investigation or recovery programme. Asset declarations. One of the most effective tools around the world in corruption cases. Although I did a series of cases for Nigeria where very senior public officials had made asset declarations in Nigeria showing that they had next to no assets, and bank accounts in London turned up with millions or tens of millions of dollars in them. Now, we had limited information in some of those cases where that money has come from, but obviously we had a huge head start in the civil cases we were bringing, because we could demonstrate that that person had lied about the assets that they had to their own authorities. They had lied to the banks in which they opened bank accounts and so on. And that takes you a long way forward to being able to prove on the balance of probabilities that their assets are corrupt. Should there be more asset declarations made public? Probably yes. There's a very interesting scheme in Argentina where the asset declarations of all public officials have to be made public, so they're there for all to see, so that civil society groups can investigate those public officials who they are concerned are wealthy in circumstances that are unclear. But it is a criminal offence to use that information for the purposes of selling goods and services to those peoples, for telemarketing or whatever, or such things, or indeed to publicise those assets, save in the context of allegations of wrongdoing, which I think is a very interesting model indeed. Some people go further and say that where senior public officials at least have made asset declarations and have falsely made asset declarations, there should be confiscation of assets without more that have not been properly declared by them. Interesting thought. And finally, mutual legal assistance. One of the barriers in this field is the ability to transport information between criminal and civil mechanisms. You can gather evidence through mutual legal assistance internationally, but you can only use it, generally speaking, either for a criminal investigation or prosecution, or for the confiscation of assets following criminal conviction, and sometimes for civil forfeiture. Can't be used in private civil proceedings. That's been a barrier in many cases. Should there be the ability to use that evidence more widely? Just some concluding thoughts to think about, and now we will take questions.
Right, so we've got that's not working. We've got about 10 minutes or so. Yes, if you can sort of shout loudly and say your name.
What were the specific claims that succeeded, and were there any claims that succeeded but you were unable to recover the land, which was the subject matter of that claim, and what happened in those cases?
Let me deal with the second question first. There were cases where the land that we were seeking to recover had been sold on to a third party. And in that situation, unless one could demonstrate that there was knowledge, or at least turning a blind eye to the circumstances which had given rise to our claim, then under TCI law, under English common law, the right to sort of go after the land is lost there. So there were cases where the land had already been disposed of, and so we were restricted to effectively damages claims. We were effectively going after the proceeds of sale. And that's a not uncommon problem when you're looking at asset claims, is following the asset. I mean, it's not normally quite as difficult with land, but certainly with portable assets, it can be very difficult if they have been moved on and sold on. And so we did have some of those issues, and you know, so there's nothing you can do about that if you can't get down the chain, and you're then left with following the proceeds, following the money that were the proceeds of the sale. Our claims, our claims were sort of very wide variety of claims. So we had everything from unwinding agreements the government made, development agreements, unwinding land sales that had taken place. We had, as James mentioned, there were what we call flipping claims, where land had been sold cheaply to a local person on one basis, discounted under the policy, and then sold on immediately at an enormous profit to someone else, to a developer for a different use. And safeguards that should have been there were not put in place to stop that happening. We had stamp duty claims where duty had been avoided through schemes to deal with that, so that the full duty was not paid, and everything in between. So sort of a whole range of different sorts of claims. We had about 65 of them. The question was, did some of the developers lose their land?
I didn't follow it very closely, but I understood that there was some special circumstances where some government officials sold land to developers at an undervalue. And I was wondering whether those developers as well also suffered the loss of the land.
We've had a sort of mix of answers there. In some cases, there's been a renegotiation of the agreements with the developers. In some cases, by way of settlement, developers have given back some land. So there's been a range of responses to that situation. And the government obviously has to be sort of careful as it goes through this process, because it recognises that there's substantial investment in the country, and if people investing feel that their investment is going to be attacked, then that is antithetical to investment, to all the things I was talking about that the government is seeking to achieve. So there's a balance to be struck on a case-by-case basis about what the right approach is on the facts of the case. And that's something that I think government has been very conscious of, is trying to balance that, where it may have a claim, but the broader impact in relation to the investment community. And the investment community both does not want its investment undermined, but it also wants to know that it is it's in a operating in a framework which is strong, and where wrongdoing is not tolerated, because that's also important for investment as well. So these things have to be balanced, and I think they have to be looked at on a case-by-case basis. Right. Who else had their hand up over there? Yes.
Thank you. My name is Dan Wise. Following on in part from the last question, I wondered whether there had been claims made against bribe payers onshore, where there might be some useful legislation available. I'm thinking particularly in the United States. I wonder if that formed part of your recovery process at all. If the facts supported that, maybe they don't.
Yes, I mean, there have been such claims, because in some of the cases that Sir Robin highlighted, the bribe, the payers, if you like, were the developers who, in exchange for improper conduct, obtained something better than they might otherwise have done. Those cases actually mostly dealt with through ordinary civil process, and actually have pretty much all been finished now. Where there's a civil remedy under English law and TCI law where you can recover the bribe as an element, as a head of damage. So those claims were dealt with in that way in the civil proceedings.
There weren't proceedings brought, for example, in the United States. If there were, potential defendants in the United States, I don't know if there were or not.
Well, the US side has really been managed as part of the criminal process, so we have not been involved in it, and it's generally been looked at as a sort of at an intergovernmental level between enforcement authorities. And obviously in the US there are a wide range of powers, as we know. But that's generally been done on the criminal side. We've not been involved in that. we were really exclusively focused on the remedies available under TCI law in the courts to the government as a private citizen. But there's a common law remedy there, which we found gave us what we needed.
Thank you very much.
Pleasure. Yes, sir. So the microphone went the other way, but hopefully it'll come back.
Van Gator. Asset recovery is often an expensive undertaking. You've given what you've said to us, 23 million and 3,000 acres. What do you estimate to be the monetary costs for recovery in those instances?
Well, it's a significant undertaking, and the costs are a matter of public record because the government has been producing information fairly regularly about the costs. The total cost of the civil recovery program, I think the last reported figures were just under $15 million over its entire life. And that includes not only us and the barristers, but everything else associated with it. And that's over 10, 12, four and a bit years. So that sort of gives you a sense of the cost of the program. The government obviously wanted really from the outset to try and ensure that it was cash positive as quickly as it could be. But the real aim here, or not the real aim, but I mean the real sort of trophy, if you like, was recovery of the land, because that was, that is worth. It's almost priceless, some of it, in terms of its long-term value to the government, because obviously land is finite, and a large part of it had been divested by the time Sir Robin came to write his report. And that resource has an enormous long-term value to the government, not just for the people, but in terms of long-term asset streams and revenue streams.
Sure, and I would think it's reputation as a country to try to get that back on track. Right. It was worth it.
Just one other question, please.
Sure.
The 23 million that's due from as damages, are they from persons who have means? Is that from person who has means?
Most of it's actually it's been collected.
Oh.
So I think I can't quite remember what the actual cash figure is but I think it's coming up to or getting close to about 20 million, maybe 18 or 19 million. We've sort of it's been collected as we've gone. That's always, again, there's always a risk there in relation to civil recovery programs of obtaining judgments that you can't enforce. And again, that's something you have to look at on a case-by-case basis. You may have the best case in the world, but if there's no one there to meet the judgment, there may not be a lot of point in pursuing it. And we've been fortunate that we've been able to obtain, we've been able to collect in the money as we have gone. We're sort of pretty hopeful in relation to the balance that people are mostly good for the money. So we haven't had a major issue on that, but it is a very serious consideration that you have to think about when you look at these programs. Yes, sir.
Yeah, there were certain institutions like say TC Invest, which I think came
No, in fact, I mean, there is an investment body which is charged with looking after and encouraging development and investors, and it's had quite a lot of success over the last 2 or 3 years. So attracting inward investment and having people there to be able to do that and to help investors. I mean, I think the role of that sort of body, where it becomes very, very important, is to help people who are new to the islands, investors who are new to the islands, find their way through government to ensure that they talk to the right people and they can invest in a practical way and don't find the process too cumbersome or difficult or time-consuming. So I think this is strictly speaking outside my direct remit, but there's a very important role for that sort of investment advice to people who are not, say, familiar, who are new to the territories, and that has been an important part of what the government has been doing over the last couple of years. So the short answer is yes, government's very committed, I believe, to ensuring that investors have people that they can work with who will help them make those investments. Any other questions? And we are spot on 10:30, so that's probably a good time to finish. Thank you very much indeed.